Good morning. Thank you for joining us for this, the Sale of Real Estate Co-Owned by Divorcing or Divorced Couples webinar. This webinar is the 12th in the 2015-2016 Maryland Association of Realtors Webinar Thursday series and one of the free MAR benefits. You can view the entire schedule on our website at mdrealtor.org under Top Destinations. Today's webinar will be recorded and available on our site early next week. Our presenters this morning are Yvonne Deerdorf, Esquire Chief Operating Officer and Vice President, Lakeside Title Company, and partner Deerdorf, Rath & Pitchen. Fred Coover, Esquire, founder and principal attorney, Coover Law Firm, MAR Mediator. This webinar will provide realtors with practical insight into the difficulties and issues surrounding the sale of property when married persons divorce. Feel free to ask questions throughout the presentation. Thank you, and let's begin.
Okay, I just wanted to introduce myself briefly. This is Kathleen D'Artez. I am the Director of Legal Affairs for the Maryland Association of Realtors, and I am going to be basically, I guess, facilitating the webinar today. And as questions are submitted by everyone who's listening, I will direct them or sort them and forward them to the participants. So hopefully we'll be able to address all of your questions. And I guess we'll get started by going through the presentation that we have. We turn the page. Yvonne, do you turn to the first slide?
Yep, there you go.
Okay. These are the panelists. Everyone can see. That's Yvonne and Fred. And we were just going to, I guess we'll just jump right into it. And again, as we had said earlier, just submit questions online and we'll address them as they come in, or in a way that makes sense. The first thing we wanted to talk about is a common situation. I guess a separated couple jointly owns a primary residence as tenants by the entirety. Once the divorce is final, can creditors place liens or judgments against the home due to the debts of one of the former spouses? So this would be basically the couple has been divorced, they're selling the property, you're going to settlement, and there are some debts, and they want to know what has to be paid, what doesn't have to be paid.
Well, good morning. This is Fred Coover. Yvonne, how about if I take this one?
Yeah, since it's your bailiwick.
All right. What we have to keep in mind, we all know that most of the time married people take title to their real estate as tenants by the entirety. That provides that shield of protection against the liens of the individual married person's creditors. The law views the marital union as the owner of that property when it's titled as tenants by the entirety. What some people don't realize, often the owners, is that the instant their divorce judgment is entered, magically, without any further action, that marital union is severed. The tenants by the entirety is converted automatically to tenants in common, and that's very important because at that moment, the judgment liens that were unable to attach to that property until that moment the parties were divorced actually can spring forward. That shield of protection is eliminated, and the liens attached to the separate interests of the then divorced persons in that property. So the answer is the creditors of each owner can lien the owner's interest in the property. That lien doesn't technically attach to the interest of the other owner. We're now talking about two divorced persons at that moment. The lien doesn't technically attach to that person's interest in the property, but the technicalities really don't help when you're trying to get this transaction to settlement, because the lien on a half interest is effectively, from a practical standpoint, a lien on the entire interest. You can't get it closed, and the bottom line is that these liens have to be released in order to sell or refinance that jointly owned property. And that other owner, the former husband or wife, is pretty much held hostage until those liens are released. And quite frankly, from a practical standpoint, much of this can and should be dealt with in a proper agreement done before the parties are divorced. It's rarely even addressed in any judgments of divorce.
Right. So I'm here today, Kathleen, to talk about the title company perspective on each of these questions.
Right.
And the realtor has a really difficult job because they need to assess a couple things early on in the transaction. You know, number one, what is the status of the divorce? Are they divorced yet? What is going on? Are there outstanding judgments? And it's a tough position for them to be in because sometimes they're just trying to obtain the listing. So it's tough to be the person to give that you know, the bad news, so to speak.
Right.
If I could follow up, I've been doing this for 30 years, and it's very clear to me that often, you know, post-divorce, people think they know what their legal situation is. Sometimes, most of the time, quite frankly, they're very confused. They'll often tell the realtor that their lawyer said something, or they're certain that a situation is as they think it is, when really it's not. I'm not suggesting these owners aren't intelligent. I'm just saying it's such a confusing process they come through. And it's usually, no matter how well handled, it's a mess. When the assets, the marital assets, are then having to be dealt with, whether it's right after the divorce or, quite frankly, in my experience, more frequently, years later. You know, maybe the former wife stayed in the marital home for 3 years or 5 years, and in that time, all kinds of things can change. And we'll address some of those issues in some future slides here this morning.
Right. You know, I just have one more question. This is just me asking maybe for clarification on the first slide. Is there any distinction between federal tax liens, like the IRS, and any other creditors, or would it be the same result?
Yeah, this I think is my area. Federal tax liens are a different animal. They're going to automatically attach even if the couple is still married and still holding title as tenants by the entirety. So, you know, a federal tax lien, even if it's just against one spouse, is still an issue. So that is different. State tax liens, however, you are shielded by the tenants by the entirety until it's severed and becomes tenants in common.
Okay. Okay. I think we're good on that. We move to the next slide. This one addresses another situation where the separation agreement is signed stating that one spouse is solely responsible for the home and all related debts. If the home was never refinanced and the spouse responsible for the mortgage makes late payments or no payments, is the other spouse's credit affected?
Let me take this.
Fred?
The answer is yes. The other spouse's credit is affected. We have to understand why. I mean, we have to bear in mind that no matter what that separation agreement says, no matter who the separation agreement says is responsible for paying that mortgage, the mortgage is legally the joint obligation of both borrowers. And the private agreement between the two borrowers, you know, trying to assign that responsibility is irrelevant to that lender's rights. Those late payments get reported by the lender to the credit bureaus for both borrowers that are on that loan. And the reporting of late payments, in my experience, and I'm certainly not a credit expert, but in my experience, late reporting, or the reporting of late payments, damages each borrower's FICO score. It costs them money ultimately in the long term. Do you have any follow-up, Yvonne?
We hear oftentimes, especially when these properties end up being in an upside-down position, and maybe the conversation is they want to sell it and they want to do a short sale. This becomes a big issue because, you know, you've got two spouses that are jointly obligated on this mortgage, and maybe you only have one spouse that wants to sell it, and they'll reach to the agreement and they'll say, oh gosh, you know, I've got this agreement that says that the other spouse is really responsible, and I'm going to show the lender this, and I'm going to get this short sale accomplished. And Fred's right. The lender doesn't care. It's irrelevant. The lender has the right to collect against each borrower. I mean, they're jointly and severally liable for these mortgages, and the realtor needs to be fully aware of who owes money and who signed these mortgage obligations when they take the listings.
Right. I think this is just, again, Kathleen commenting. I did foreclosures years and years ago, and this is a very common situation where one of the spouses thinks, well, we have an agreement where I'm not supposed to pay the mortgage, my spouse is supposed to pay the mortgage, so I'm good, my house is not at risk, everything's going to be fine, and that is actually not the case.
If I could follow up, Kathleen, if I could follow up, in my experience, the minute that the people get divorced, they don't want to look backwards. They want to kind of repress all of that and only think about the lives they're going to have that lie in the future. And often the spouse that thinks they have no obligation to pay doesn't check with the lender, doesn't go online to check the loan history, stays completely ignorant, and they could easily know what's going on, and they should check regularly to make sure that their former spouse is making those payments. Because if they're not, then they might want to be thinking about trying to change that, whether it's enforcing an agreement that set that up or even a court order. They just shouldn't wait for 2 or 3 or 5 years and then suddenly find out about it when the title company contacts them to say they've got a problem.
Right, right. Good point. Good point. Okay, the next issue is if a former spouse is still on a mortgage, will that prevent them from buying or borrowing in the future if a separation agreement requires the other spouse to pay the mortgage?
This issue is so typical, and it's just we're picking up on the last slide that the problems just kind of compound. The fact that the former spouse is on the mortgage is absolutely going to impact them. It doesn't change. The fact that there's a separation agreement doesn't change their status as a co-obligor on that mortgage. That existing obligation absolutely affects their credit worthiness. It's considered by loan underwriters. That existing obligation affects both of the parties' ability to borrow. And I guess if there's good news here, it is very clear to me that lenders are these days, and they have been, they will look at these separation agreements. They will see who's responsible to pay what, as part of that underwriting process. And I suppose in, borderline qualification situations, the terms of that agreement may very well get that former spouse approved for that loan that they need. So the agreements are very important.
Definitely. So my follow-up on this would be, and this is Real Estate 101, realtors should be getting their buyers pre-qualified, and part of that pre-qualification process may be a review of their separation agreement. Depending on the entire financial picture of that spouse, the loan program, it depends on whether maybe they're doing USDA or FHA. There could be all kinds of reasons where, or factors that go into it, but they should expect that agreement would be reviewed and looked at very carefully, and when they're going through the divorce or going through the separation, there might be particular language in the agreement that an attorney like Fred would include that would make it more likely for the lender during the loan underwriting process to consider the obligation. It's going to still be a joint obligation, but depending on how it's drafted, the lender may like it a little bit more and give the spouse that's no longer technically obligated to pay it maybe a little bit of preference. So I think it's really important to make sure that you've got a good divorce attorney that's working on your separation agreement ahead of time, and then understanding they look at how long it's been in place. There might be a need to provide copies of payments, just a lot of different, it's loan underwriting, but getting your buyers pre-qualified is definitely very important.
Yvonne, you make a very good point. In my experience, so many divorce lawyers really don't understand real estate. Quite frankly, I think probably half of them don't even know what a short sale is. And so, I've been doing real estate and divorce law for over 30 years, but the reality is that if I want to say that properties being upside down is more the norm than the exception now in my practice. And So many attorneys, when they're drafting agreements, they just want to kind of like stick with the form language that, quite frankly, usually doesn't say anything, or it's not sufficient to deal with these very prevalent and very difficult issues. And often the agreement, you know, if it's written well, if it's tightly written, and if it has consequences, if its terms are breached, that agreement can really serve as a club to extort or induce the other party to do what they're supposed to do. It's very important. So I think your point is spot on, Yvonne.
Yeah,
Good.
Definitely.
You know what, I just wanted to insert, we have a question that was submitted as we're talking about sort of planning, I guess, and looking forward. This question is, if the couple owns, you know, they have their marital residence, their primary residence, and an investment property, and they know that they're going to get divorced, is there an advantage, or I guess discussed, should they refinance one or both properties as part of the divorce? Would there be an advantage to doing that? I guess if, you know, say the wife is going to stay in the marital residence and the husband is going to take the investment property or take title to the investment property, does it make sense for them to refinance during or as part of the divorce?
Well, I'll answer the real estate piece of it, and then you can talk about the divorce piece. But they really need to, first of all, look at what the value of the property is and what they want to do moving forward. You know, and are they going to be able to refinance? And will they be able to refinance now? More likely, you know, and can they get along at this point to do that? I mean, sometimes, you know, they're in the heat of the moment. They can't look forward, right? They're too busy worrying about their child custody issues, or whether their retirement account is going to be, you know, hacked by the other person, or what's going to happen. So yes, it would be great to look forward and figure out. I mean, and I'll give you a personal example. I'll put my personal out there. When I was divorced 10 years ago, we were in this situation, and we decided that we were actually going to buy another property in my own name, with my credit ahead of time, so that when we disposed of these other properties, we were in a better position. So, I mean, if you can get to that point, it's wonderful. I think the issue, and Fred can address it, is just the emotions that surround a divorce.
Well, I couldn't agree more. I think it's a rare situation where divorcing couples are able to put aside their anger and make good business decisions. It's wonderful when that happens, and it's rare. I'm not sure that refinancing either the primary residence or the investment property, the vacation home, before divorce is a good idea unless that's already part of a very tightly drafted agreement. Because we have to bear in mind that we're creating or perpetuating an additional joint obligation, and there may be a plan in place among the divorcing spouses where ultimately one's going to end up with one of the properties and the other's going to end up with the other one, but that would need to be clearly specified in an agreement. I think that from a lien standpoint, it may be possible to refinance while they're married, and under circumstances where the instant they become divorced, they might not be able to refinance because of those liens that I talked about earlier this morning. So this is really a rare situation. It's probably an opportunity that should be looked at carefully.
Yeah. Well, plus the other thing, Kathleen, is there might be leverage issues in the divorce. You know, it might make sense for one spouse to refinance and put everything in their name. But again, without an agreement, they might be taking on an obligation that later on they then lost their leverage to get something else they may want in the divorce.
I see so many times the house is jointly owned, but only one of them is the borrower. That happens much more than you might think, and that's played tactically in separation and divorce. And so, I mean, even in that situation, if the existing lien only has one of them as a borrower, and the suggestion is that now they refinance into their joint names and they're going to get divorced, that might not be the best idea, again, unless there's some trade-off, some value that's going to be exchanged, and that would be in the agreement.
Right.
Right. Okay. All right, I think we're ready for the next scenario. If the spouse who assumes responsibility for the mortgage doesn't honor the terms of the separation agreement, does the other spouse have recourse?
All right, go get him, Fred. This is you.
You know I'm laughing.
This is his specialty.
Yeah, I'm laughing
club.
because the answer is yes. But, you know, here's the bottom line, folks. Sure, a separation agreement is a contract. And many times that agreement also becomes part of the court judgment of divorce. And so the recourse can be both enforcing that contract as if they weren't divorced, just like a real estate contract, enforcing it for breach of contract. And also, if it has become part of the judgment of divorce, it can be enforced through court action, including an action for contempt of court. But all that's easy to say. There's some practical limitations on this, and that is, quite frankly, court enforcement actions require months. I mean, easily months. Think 6 months or longer to come to conclusion. 6 months is an incredibly long time, especially when you good folks are expected to solve all the owner's problems and get the transaction to closing. So though enforcement is absolutely available if the agreement's done properly, and if it's specified in a judgment of divorce, the trick is not actually enforcing it, but threatening the enforcement. What I want to say is you want to use the threat of enforcement to induce the other party to do what they're supposed to do. Or in this situation, the context of this question is if the other spouse who has responsibility for the mortgage doesn't honor the terms of the separation agreement, again, if you're finding out months, if not years later, that they didn't pay that mortgage, nothing's going to quickly change that. You may lose that deal, but yes, that innocent spouse, for lack of a better description, does have legal recourse back against their former spouse, perhaps for the damages that they incurred because of that breach.
Right. You know, a question related to this, I guess this slide deals specifically with the relation between the parties, I guess, you know, their ability to enforce their contract. A question has come in about whether the separation agreement that assigns responsibility to one spouse, would that prevent the mortgage lender from seeking payment from the other spouse? We kind of touched on that already, but
yeah, no, it wouldn't.
Not at all. The separation agreement is an agreement, a contract between both spouses. That mortgage lender is not a party to that contract. Right. They can do anything they want within the terms of that mortgage document, deed of trust document, and their promissory note.
I think where the realtor really needs to be careful when there is a separation agreement is to make sure that they've got the proper parties signing contracts, signing listing agreements, and they've got, they've got cooperation moving forward. Because, you know, I mean, this is aside from this question about recourse and the mortgage. It's other things that are going on that are related to the potential real estate transaction itself. You know, they want to make sure that they understand what it says and what the obligations of each of the parties are, and before they're taking these listings.
I'd go so far as to say, Yvonne, that the realtors shouldn't rely upon the information that one or both of the owners are giving them. They should try to independently verify that information. I'm not suggesting that all the owners would misrepresent anything to the realtors. I am suggesting that some will. I'm also certain
some might just not
they
understand.
just don't understand.
Yeah.
That's just the reality. And so getting copies of the judgment of divorce, getting a copy of the agreement, checking online to see, you know, what SStat shows in terms of ownership, running Maryland land records to see if there's any recorded instrument. Real quickly, you can do that, you know, sitting at your couch in the evening. I think doing a little bit of background checking, a little bit of diligence might save a lot of heartache and headache for the realtors later.
The realtor's job is difficult enough already, but what will end up happening is part of the way through a transaction, and now there's other parties involved. If it's a listing, there are buyers involved, and then you have sellers who are disputing, well, who's to pay the BG&E bill during the contract period? Who's going to make sure that the repairs are made on the property? And these are all things that the realtor may be put in the position to almost mediate. So having the information up front is going to be very important to them, so they can see what's coming.
I had a recent case where the wife, this was a married couple, the wife, they had some financial problems, and the wife wasn't aware. She thought they had one lien on the property. And folks, they ended up having 5 liens.
That's
the
all.
house would have been upside down with just the one. There were 5. And I knew this young woman. She was an honest woman. She had no idea. And she was a smart lady. She had no idea there were 5 liens on her property. And of course, part of me wants to say, how could that be possible? And yet it was. You know, it's just, so a little bit of diligence, asking the questions, and then looking behind them for more information, I think is just hugely invaluable to you.
All right, I think that's good. Are we ready for the next slide?
No. I guess
All right.
this
Getting into your title section. This comes up all the time. I've heard people asking, when is a quitclaim deed appropriate and what are the risks? So I guess let's say one of these other examples, if there was a separation agreement maybe and one spouse had agreed to make the payments, would that make sense for the party to do a quitclaim deed to either one of the spouses?
We hear this term all the time. We'll just quitclaim it to the other person, or
Right.
we'll do a quitclaim. And quite honestly, a normal deed, and I know realtors know this because I know that they hear it over and over again in CE training, but the special warranty deed is typically what's given, and the slide says it. I promise good title, you get good title, you have recourse. In a divorce, typically the deed is I promise nothing and you may get nothing. Or it can be a special warranty deed that they've done nothing to encumber the title. I don't know that it really matters. I mean, when we're looking at issuing title insurance, we're looking for liens. We're doing a title search. So even if it is a quitclaim deed, we're still doing the title search that we always do. I don't know that it wouldn't prevent us from issuing title insurance as long as there were no other liens out there or other issues. So, you know, I don't know that it's really all that important, if that makes sense. I wouldn't get tied up in the name of the deed, what you call it.
As a counterpoint, I have a very different perspective, but I want to recognize that my perspective is absolutely subject to the ability of the title company, kind of at the end of the process, to solve the problem, pass title, and better yet, insure it and insure the loan. But I'm worried years earlier than that. I'm worried that either my client, or more likely the other spouse, is going to do something in that long period of time to screw up the title to the property. Now, if they do that, Yvonne's going to find out about it when she runs title. But my job is to try to prevent them from doing that if I can, to assign consequences to them if they do, and quite frankly, to be able to go after them if they do. And we've kind of touched on that earlier this morning. And so from my perspective, if I'm focused on making sure that when we get to that settlement table, that my client, and their former spouse are going to have clear merchantable title, and that nothing that their former spouse could have done in that long period would mess that up, I'm absolutely going to require a special warranty deed. I want those warranties in there. I want that recourse. I want to be able to waive that deed literally and figuratively at the attorney for the other party. I do. And quite frankly, even if I waive it and they ignore me and the deal craters and it doesn't settle, then I have something else to go after that spouse who messed things up and shouldn't have done so, you know, and by doing that, maybe even deliberately frustrated what the parties agreed to do.
Right.
So I'm absolutely focused on special warranty deeds. In my world, quitclaims are for a very limited context, and separation and divorce is not among them. But I think the message here this morning is, but even if all you have is a quitclaim, ladies and gentlemen, if you got a good title company, they can fix these problems, you might be okay. Is that a fair statement?
Yeah, we're not gonna issue the insurance unless the title's clear, or that and if we find something, we're gonna fix it. And your perspective is you want the special warranty because you want to be able to have that leverage or that hammer to go after them if we get to that point and there is a problem.
And ironically, sometimes, depending upon who I represent, I might be concerned that they're the very people that are going to do something, and I might and I might push for a quitclaim deed. I mean,
well, I'll be watching that when I see your agreements come over.
Ladies and gentlemen, you have to bear that in mind. The lawyer's job is to represent their client in the deal, and so often the agreements are reflective of whatever issues that lawyer was focusing on at the time, and it might appear to you that something was omitted or handled poorly, or why didn't they put in a special warranty deed? Maybe my opponent didn't know the difference, and maybe I was worried about my client screwing up the deal. So, but honestly, on balance, I think it should be a special warranty deed.
Right.
Sometimes you represent the not-so-innocent spouse, right?
All too often.
Yes, unfortunately.
All right, we'll go to the next slide. This is a good question. I'm sure this comes up all the time, too. Can a separated spouse act as a power of attorney for the other spouse?
Well, the answer is yes. I mean, there's many spouses that get along well and they want to do a power of attorney. But I will just say this about power of attorneys. They are all reviewed very carefully. 95% of the claims that occur regarding title insurance claims are because of power of attorney issues. So every time a title company is presented with one, we're looking for legal sufficiency to make sure it's executed properly, it's witnessed properly. We're looking for the circumstances. We're looking at when was it executed. What was the person competent at the time of execution? We're filling out forms, we're getting information. And I can tell you, realtors get very frustrated with me when I ask those questions of them. They say, we're just going to use a power of attorney. And even if it's not in the context of a separated spouse, I mean, that is a heightened review when we see that. But power of attorneys are just, they're a problem. Any legal document executed by an attorney, in fact, is going to be looked at carefully in the chain of title moving forward. So, we want to make sure that there was authority. We want to make sure that we're not seeing a deed that looks like it's self-serving. I mean, we had one a couple weeks ago where we had a divorcing couple. They were divorced, but as part of the divorce, one of the spouses executed a quitclaim deed from the other spouse to him. Well, clearly it was self-serving. Now, as we dug into the situation further, we were able to find out that there were reasons for that. It was actually specifically stated in their separation agreement that this was supposed to be done. The judge spoke about it in the divorce decree. We had a spouse that was out of the country. We had there was all these different facts, and I guess all of that really isn't all that important, except for the deed that was drafted was just a quitclaim deed. And what we ended up doing is we had to go back to the title insurer and we had to say to the title insurer, look, this is the situation. This is why it was done. Can we issue title insurance? And what we ended up doing to correct it is we had another deed, a corrective deed drafted that actually stated all of those facts, that included a copy of the redacted separation agreement, that included a copy of the divorce decree, so that when someone was reviewing title, they could actually see why it was there. And that made it, that's how we ended up dealing with it. But, legal documents on their face look valid all the time, and that's really what title insurance is for, is to cover the buyer and cover the lender in those circumstances when it looks fine, but really there's a problem. So we're looking at these, it's really not a great idea, and Fred's going to tell you absolutely not, never. And I think that there's just very limited circumstances where it should be done.
You know, Yvonne, that case that you just spoke about is kind of like the stereotypical nightmare. And I can tell you folks that Lakeside has an excellent reputation for doing things right and for fixing these really thorny problems. And when I say doing them right, I mean doing it right so that if I look at the title 10 years later, the story is told, the repair is clear. It has to be in something that's recorded among the land records. But I don't want to get off point here. I would say this, powers of attorney should be a red flag for you. You should flag it the instant you get involved at that listing appointment. You should ask the question. If one or both of the parties tell you that they want to rely upon a power of attorney, you should get that power of attorney immediately, and you should get it to Yvonne. I mean, don't wait. Get it to Yvonne, because too often these things appear for the first time, you know, the day before settlement, if you're lucky, maybe the day of settlement, you know, oh, I thought I could just show up and use this power of attorney. Here it is. What's wrong with this? I can draft powers of attorney, but 99% of the time, when they're going to be for a real estate transaction, I say to my clients, go to the title company that's going to be underwriting this, that's going to be handling this. You know, deal with it correctly that way. And unfortunately, most of the time, the powers of attorney that already exist weren't drafted by the attorneys at the title company. God knows who they were drafted by. Many times they're upon very strange terms, and they're stale or old, or what we call outdated.
Or too new.
Yeah, and so it's, yeah, and I would say, and there is absolutely a significant tendency for them to be fraudulent. And so I would say steer clear of them at all reasonable cost. But Yvonne, I won't say never, because there are absolutely legitimate reasons to have powers of attorney. I mean, often a co-owner, divorced spouse or not, is going to be out of the country, and it's unavoidable. But those are the exceptions. I think the rule should be don't use them. Try to get everybody to be present personally, and that's what we deal with when we put together, you know, the deal years earlier. We kind of are aware of these problems and we try to deal with it that way.
Well, the realtor also wants to make sure their listing agreement is considered valid. So if you've only got one spouse executing a listing agreement,
I would be very wary.
I would be very wary of that.
That's probably not an enforceable listing agreement, folks. And I mean, let's just be real clear. That divorce or divorcing spouse is probably not, even in the absence of a power of attorney, the agent for the other spouse in terms of binding them to you in your listing agreement. I would be very wary of that. And I have, you know, it's not that frequent that I have to go look at listing agreements, but I do. And I'm amazed how often only one signs.
Yes.
Right.
I mean, that's not legally good enough. And you know what, folks? You get them signed for many reasons, but you want to be able to enforce them if you have to. None of you are working for free. You want to get your commission. If you don't have a good listing agreement, if it's not valid, it's a whole lot harder to get paid if it's challenged. And there's reasons. Let's be honest. Divorcing spouses they've just come through litigation. You know, they might, by personality and nature, be litigious. They might be looking to take advantage of anybody that gets in their way. And almost all of them, but not all, are financially devastated when they come through this process. You know, not all of them, but it's a very expensive process. So sometimes they're looking, and who do they point to first to take the haircut? I've seen it way too many times. The realtor has to kick in to pay off whatever, take less to get the deal to settlement. So I would say no matter what, steer clear of powers of attorney if you can. Don't rely upon a power of attorney on your listing agreement. Try to get both owners to sign and make sure that you know who the owners of the property are. Because you know what? It may not just be the wife and the husband. They may have put their mother or mother-in-law in title as well. This happens all too often. It creates all kinds of other problems. But the mother-in-law now has to sign that listing agreement also. Just bear that in mind.
Right. Or there may be a trustee appointed in the divorce.
Right. Just actually, we had a question in, just speaking about other parties. A question came in with from an agent who is starting to work with a couple, preliminary conversation with a couple who is separating. They're not married. They were unmarried and they purchased the property together. They held title jointly. And she just was wondering if we had any suggestions or tips to help work with a couple who's not married but basically going through the same process. So I guess based on everything we've discussed before, would there be differences for a couple who's not married?
I think the only substantive difference, based upon what we've already discussed, is that since they're not married but they co-own the real estate, obviously they can't own it as tenants by the entirities. They might have it as joint tenants, or they might misunderstand it and have it already as tenants in common. But either way, either of their judgment, their creditors, the liens of those creditors do attach to that property. Putting that issue aside, it's pretty much the same. The fact that they weren't married doesn't really change anything. We still have all the same issues. And I take from the
Oops. Hello?
Did we lose them?
Can you hear us?
Yvonne?
Your audio faded out.
Yeah, I think it gave me a little thing here that says our network connection. Maybe it's the weather. I don't know.
Can you hear us now?
Can you hear us?
I can.
Okay, good. Yeah, I think the biggest issue with couples that aren't married, it's very likely that there isn't an agreement to follow. You know, it's really going to be the real estate agent working one-on-one between these two people, crafting the deal in many cases.
Can I inject this? And I know it's not the question, but I think it's an important one for each of you to bear in mind.
The audio is out again.
That is, and who's going to be responsible under what circumstances in the future, including when that relationship ends. I know that's a little odd, but all too often this happens. It especially happens with the younger set. You know, they're blinded by love. They're going to buy something together. They can save money. Instead of paying 2 rents, they're going to buy 1 house and save 50%. And they trust each other implicitly. And the relationship blows up a year or 2 later, and it's a mess. You know, and so if you have influence, I would almost beg that you influence them to go to an attorney and get a document. All right, it's not a premarital agreement. It's not a prenup, but it's a partnership agreement. It's a document that deals with these issues ahead of time. They're horrible to unravel when there is no.
And unfortunately, 99% of the time, that document never exists.
It doesn't. Because I'd say even higher than that.
99.9.
You tell people these things and they just don't do it. But the failure rate is very high. The failure rate of these unmarried relationships and co-owning real estate, it's probably as high, if not higher, than divorce.
Right.
Definitely.
Actually, let me see, another question came in. We sort of have touched on it a little bit, but maybe we can just address it more directly. It was any tips for realtors working with separated couples where there's no separation agreement and where both are on the title but only one is named on the mortgage?
Well, I guess, Kathleen, I think I cut you off. What did you say?
It's any tips for a realtor who's working with a separated couple, no separation agreement, both parties are on the deed, but only one of them is on the mortgage? That's
kind of typical. It's a nightmare waiting to happen. I'd be very careful if I was the realtor. The fact that only one is on the mortgage is typically used tactically. I mean, let's be honest. They both own, but only one is on the mortgage, and honestly, often the house is upside down or close, no matter what. And people are thinking about a walkaway situation. There's no agreement in place to deal with those consequences. And so often people are thinking, well, what do I care? You know, nobody can come get me. I don't have any equity in that house. I can walk away. What am I losing? And that lender can't come after me. I'm not on the note. It's a mess.
I think if I were the agent in that situation, I would try to get them both together at some point, and I don't know whether, sometimes they are working together sometimes they're still living together. I mean, we're seeing now a lot of times they're separating and they're moving, and one's living in the basement and one's living upstairs, and there's, you know, all kinds of issues going on, emotional, everybody's emotional. But if I were the agent, I would want to figure out what's going on between those two parties. What are the motivations of each of the parties?
You know, I think often you all are in an amazingly powerful role because they come to you first. They view you as the savior. They confide in you. They trust you. They don't want to go to the lawyer. Maybe they're so tired of lawyers they don't want to ever deal with lawyers again. And you're unfortunately in a situation where you've got to herd cats because you've got two people who already usually can't get along and can't make decisions together. And I think that you can be and should be the voice of reason. It's going to be your job to recognize these issues, to flag them, and you know, to calmly make suggestions to them about what they could do. These problems can be dealt with, and they can be solved, you know, as long as they're anticipated and both parties are kind of invested in that resolution. Wouldn't you agree,
Yeah,
Ron?
getting them on the same page is really important.
And getting them there early, not the day of settlement.
Right, exactly.
Right.
Yeah, because something inevitably happens right before settlement that's going to cost more in the transaction, whether it's something outstanding, maybe it's an HOA bill, or, you know, maybe it's something that one thought the other one was paying. And, you know, the biggest thing is to make sure that the deal that they have between each other, that you understand it so that we don't have these things cropping up, interfering with the deal with the buyer.
Oh, and you know, everybody's furniture is on the moving trucks, and the tensions are running high, and then there's always that, oh no, you're not going to give us a jointly written check. I want my separate check, and there's no agreement, you know, and then what's Yvonne going to do? I'm going to write you a jointly titled check. Yeah. That's your problem.
That's one of our slides.
Right. That's your problem, and everything gets really tense. And the settlement's not quite done. These things they can be dealt with, and they should be beforehand.
Yeah, definitely.
You know, one other question came in, it kind of looping back to something we talked about just a few minutes ago, the listing agreement. The question that came in is the signature of a wife required on a listing agreement if only the husband is on the deed and there's no separation agreement or divorce filed yet?
No.
So one of the spouses owns title individually.
No. There's no requirement.
Right.
No, the only requirement is that everyone on the deed signed the listing agreement.
Right.
So if only the husband is on the deed, he's the only one in title, then he's the only one that needs to sign that listing agreement.
Right. And that's who the client is. That one's pretty straightforward, actually.
I mean, Fred could be trying to make a determination in that case that it is marital property, even though it could be
it
probably is marital property, but that's really the other spouse's burden at that point. The realtor just needs to realize who owns it and make sure they get the signature of everyone that owns it.
You know, you bring up an excellent question there, Yvonne, because the fact that folks, Family Law 101, all property acquired during the marriage, regardless of title, is marital property. So if they buy it during the marriage, it doesn't make any difference whether it's in one spouse's name or the other. It's marital property. And the reason I'm slowing down on this issue is that marital property may have been addressed in a judgment of divorce, and somebody might not be telling you about that. You might just be looking at the title and thinking, oh, the guy or the woman in title is the only person I have to be concerned with. And yet that judgment of divorce may very well effectively restrict what happens to that property and control it.
Right. And so when we do the title search, we may, and we're getting ready to prepare for closing, we may find in the chain of title the divorce, maybe maybe a quitclaim deed, maybe something happened very,
Maybe a trustee was, as you said earlier,
right.
a trustee was appointed
Right,
by the
and
court to sell the property.
we may find that that separation agreement actually says, or that judgment of divorce actually says that as a result of the sale, the spouse that is no longer entitled might be entitled to some of the proceeds. So those are things that we may find. So I think the answer is ask a lot of questions in that situation and try to say, are there any other agreements? Yes, you're the only one on title, but are there any other agreements involving this real estate that I should know about?
Right. Good. That was a good question.
Definitely.
Okay, I guess we can move to the next slide now. The separation agreement states that in 5 years, one spouse will refinance the other spouse off of the mortgage or the house. Oh, I'm sorry, or the house will be sold. What happens if the responsible spouse cannot refinance and the home has negative equity?
So I'm thinking this is probably
call the realtor.
Each of your lives every day now, times 10, because we see this so often. This is kind of the norm. This question is just loaded with issues, isn't it? 5 years, that's a huge amount of time, and so much changes in that 5 years. And it also has, the separation agreement says that one stays, one pays, and then something happens in the future. And so often, no matter what they qualified before, years before, no matter how much money they made, even if they were together today, they can't qualify for the same amount of money to borrow because of changes in the underwriting guidelines. And so often today, the house is upside down. It's a short sale. There's just so often no way, practically, that the spouse that was to stay and pay, and let's just assume they pay, but the one that was to stay and pay can actually honor their obligations to refinance out the other spouse because the house is upside down. There is no equity. They can't qualify for the loan. And the reality is that the other spouse, the one that moved on, probably has deliberately not been looking back, been holding their breath and waiting until that 5th year is done so they can get away from that house, get away from the mortgage, and sometimes honestly, naively think that they might be getting some money out of it, only to find out that it's not happening. And I know that happens all too often. So the bottom line is that you have to deal with this up front when you're putting the deal together. And I don't want to the problem that we deal with in this in advance is it's still a short sale. And if the agreement doesn't deal with a short sale is a short sale whether the property is sold the day the parties get divorced, a year later, or 5 years later. And it is the fact that it's a short sale that creates so many problems. Nobody really wants to deal with them.
And there's usually attorneys are not looking that far ahead or putting provisions in there. And the short sales that we're handling through the law firm, I can tell you that I haven't seen one separation agreement that addresses the issue. It just becomes a free-for-all, and one spouse trying to convince the other spouse to do the short sale. They're looking to the realtor for information about the process. Will it hurt my credit? What will happen? And it's just it's not a great situation.
And you know what, folks? Often the former spouse that stayed, and then they might have been supposed to pay. They're probably not, and they've been staying. Sometimes I've seen for years that mortgage has not been paid. The lenders aren't frequently or always foreclosing, and they're riding that. I've seen both genders take advantage of this situation. They're not paying to stay. They're living basically for free in that jointly owned home, and quite frankly, many times they're tactically hoping to keep that going for as long as they possibly can, even though the separation agreement, perhaps done in haste and not forward-looking, says that something's supposed to happen magically 5 years later that quite frankly can't happen. It's a real problem.
Do you ever see a separation agreement? Would it require or anticipate, I suppose, where the parties, if they can't sell the property, or if the home values have depreciated, where they're not going to be, it has negative equity basically, or do separation agreements allow the parties to try to rent a property, Or is that too much cooperation?
They can
We
say
can
anything.
do anything that isn't, by definition itself, illegal. And Kathleen, thank you for raising that, because that's a real issue in my profession, because so many times lawyers just want to stick with the form, you know, the one that's been being used for 30 years or whatever. And 30 years ago, I know I didn't know what a short sale was, you know.
Right.
Nobody was dealing with them then. I mean, I guess they existed, but nobody was really dealing with them. So yes, the agreement can deal with a rental of the property to create revenue for both parties or one of the parties, if that's appropriate. You know, so often, today we know more often than not that there is going to be a problem with the real estate. You know, years later, we can tell by, you know, the market's down, we know what the equity is in the house, we know what the market value is, we know what the unpaid lien balances are. We can pretty much tell that there's a good chance that when it comes time to sell the house, there's going to be problems.
A good divorce attorney will be foreseeing those issues, but more often than not,
they don't.
They're taking, you know, someone comes in to have an agreement prepared, and you say, how much is the house worth? And they say $500,000. Well, that was 5 years ago.
I'm shaking my head because I can't rely upon what they say. Often they don't know, and no matter what they think ends up being very different years later. I have people tell me that their house is worth X, when in fact it's worth 50% of that, because it was worth X in 2006, right?
Right.
You know, that information is just really so irrelevant to the problems that lie ahead. And the other problem that we face is, for a lot of people from all walks of life, no matter how many years of education they have, they don't want to listen. They don't want to deal with it. They're more focused on how many overnights they get with the kids, and they really don't want to pay or to pay for the expense of these terms in the agreement, and they don't want to deal with them they'll trade them off for something that they feel is more important now. Absolutely. And it's a big mistake.
Yeah.
Okay. I think that's it. Are we ready for the next slide? Okay. Actually, I just got a question that ties into this one. What happens when separated spouses reach out to a realtor to sell the marital home and there's no written agreement in place, and the realtor believes the sale will result in a short sale, and we just received a written question, actually a slight variation on that, where the couple is actually divorced. One of them resides in the property, one of them does not. You know, maybe one of them is going to not as cooperative about the short sale. What I guess maybe work the two in.
I think the first issue is the realtor needs to realize what they're really allowed to do under Maryland law as a realtor, and that is facilitate a short sale. So not negotiate, just facilitate a short sale. So when this issue comes up, the first thing the realtor should be saying is, this is a legal matter, and each of you should be speaking to an attorney. However, this is, in my experience, how a short sale works. And explain to them that if they're both obligated on the mortgage, they're both going to have to submit financial information to the short sale lender. Many times it can be submitted separately. Most of the time, because this question is, you know, there's no written agreement. I will tell you that short sale lenders will complete short sales without written agreements, without judgments of divorce. So they'll take the party's word for it that they're separated. You know, they'll take a hardship letter from each one that explains the situation. In fact, sometimes we get a better result when letters are colorful in nature. You know, I've had one recently that was a pictorial of their separation, and the short sale lender really liked that. But I'm kidding. I mean, it really was. But really, the realtor just needs to understand what their limitations are as to what they should and shouldn't be doing in these short sales, and whether it's really a good use of their time.
Can I pick up on that? I have negotiated short sales. I hope to not do that again. It has gotten better over the years, but it's still a tremendously time-intensive process. Yvonne's point about being a good use of your time is probably spot on as that expression is used. It's going to take a lot of your time and a lot of knowledge to get it to the settlement table. I know that there are realtors that specialize in these distressed properties, and so they kind of know the ins and outs. I would say absolutely. Once you flag that's a short sale and you've identified that issue with the owners, I think that you should absolutely recommend that they come to somebody like Yvonne who knows this stuff inside and out. Because these things can be resolved. Short sales are achievable, but there are so many pitfalls along the way. I think they need guidance, and I would go so far as to say, and I don't mean that you shouldn't do it. You can help, but I think the way you facilitate the best is not by actually processing the short sale. Don't assume the short sale is just like any other sale. It's not. Direct them to the right people. Yvonne would be an excellent candidate for that.
And MAR does a really great job with the forms that are out there. So I think, what does the realtor do in this situation? A great place to start, quite honestly, is reviewing the short sale addendum to the listing agreement and the short sale addendum to the contract. I mean, that is a great way to start the conversation and explain to them how the process works. I mean, if you walk through the short sale addendum to the contract of sale, it's basically telling you step by step how it works. Number one, we're going to submit our information within 5 days. Number two, we're going to have a certain period of time where the bank gets to review it and the buyer will wait during that period of time while we have this done. I mean, I feel like MAR has done a really good job with the forms, and it doesn't have to be the realtor sitting there just telling them how it is. It can be, look, let's just go over these forms. I think that's a great way to handle it.
I find, let me say this, the forms are excellent. MAR forms are excellent, but I find that people don't even understand what they mean in terms of, okay, what am I going to have to do once I sign that document? What kind of information am I going to have to collect and give to that lender? That, what I like to call that lifestyle analysis that the lender's doing to try to decide whether or not this short sale.
Well, that's because they don't have time to submit the documents. They're in Cancun, right? They're doing a short sale, but they're on vacation. We see that a lot.
That's actually a question came in. It's not necessarily that someone is in Cancun, but a divorced couple where one of them want to sell the house, but one of the spouses, ex-spouses at this point, for whatever reason, one of them doesn't really want to be bothered. He thinks it's too much trouble. He doesn't want to cooperate. What can the realtor do in that situation?
Well, it sounds like if he doesn't want to cooperate, it sounds like he doesn't think there's any money for him. And there probably isn't. I think the realtor needs to find out what the legal relationship is. I heard that they're divorced. The realtor needs to get a copy of the separation agreement if there's one, get a copy of the judgment of divorce, maybe read it through to get a better idea of what the situation is. There's a good chance that that former husband doesn't really have the legal option to not participate. And if they figure that out, if they can tell from reading those documents that he's really pretty much obligated to, they probably should suggest to the former wife that she consult with a lawyer, because that may very well prompt that former husband to do what he's got to do.
Well, and practically, a lot of times the pushback that I get, because I'll have one spouse call me that's gung-ho that wants to do the short sale, and the other, I can't get them on the phone. I can't get to them to explain to them why it might be a good idea. There's so much misinformation out there about the effect of a short sale versus the effect of a foreclosure versus a deed in lieu of foreclosure. So the realtor's job should really be getting the spouse that isn't cooperating the information that they need, and whether it's, sending them resource information by email or putting them in touch with an attorney, trying to do what they can, because, and it's a tough place for a realtor to be in, because the realtor wants to sell the house and get a commission. So the spouse that doesn't want to participate is thinking, this realtor just wants a commission. So referring them to someone else that really doesn't have a lot of skin in the game, that can give them some independent legal advice as to why it's good or bad, or what's in their best interest, I think is a great way for them to handle that.
And from a practical standpoint, the realtors have to stay neutral.
Right.
I mean, that's the reality. They can't advocate for either one of the former spouses. It's a really difficult position to be in. And you all have to keep that in mind. We recognize that your position is very difficult, if one of them comes to Yvonne or comes to me, our relationship is very different, and we can help get it to the finish line. But you've got to be Switzerland. You've got to stay neutral. The instant that the husband thinks that you're on her side, your job just got 100 times harder, right? And I'm sure each of you some of you are probably shaking your head right now, and you've experienced that dynamic all too often. And honestly, usually in a post-separation, post-divorce situation, in my experience, everybody's a little paranoid. Everybody's thinking there's some unholy alliance between all of the professionals and the other side. They just act really strangely in that regard. And this is probably the biggest issue post-divorce that they have to deal with. And so it's bringing that paranoia to the surface, and you see the effects of that in bad behavior. So I would caution you to keep in mind how you're perceived by both of them, and keep that neutral posture, but provide that information like Yvonne was talking about, so that you can help bring down the stress level, maybe address that misinformation, and perhaps diplomatically get them where they need to be. And if that doesn't work, then send them to somebody that can help. Tell them each to get legal representation.
Right. I mean, the other thing is just how you're communicating with them. I mean, as a realtor in that situation, I mean, maybe up front it's figuring out every time you email these people, are you going to include both of them on the email? Are you going to get permission? When I represent a divorced couple or a separated couple in a short sale, I'm representing both of them in the short sale, and my job is to effectuate the short sale and get them the result. But I have to make sure up front that they both want the same result, and that my retainer agreement addresses that, and that they're both working for that that result. And it's tough, and you're in the same situation.
Folks, as a litigator, I want to say this to all of you, and it's beyond the scope of this seminar, but I do want to make clear, be very careful what you write in an email. Think about it very carefully. Don't hit send right away. Never react with emotion, whether it's anger, to an email. Often, there's emotion in these transactions. I've seen where there's animosity between the listing and the selling agents, if not among the parties. I've seen terrible messes, and it's amazing what I see written in emails. I would encourage you not to do that. It's so easy to take them out of context when they're printed out and read months later. So you've got to use email. And email is a very effective way of documenting your position and your actions. Just be really, really careful how you word them. Always take the high road. Kathleen, do you think that's a fair comment?
Absolutely.
I think that's a terrific comment, and I'm just was going to point out to everyone who's listening that they got a little free risk management tip there on top of the divorce advice. That's very good, a very good practice, and in any email, really try to keep it as factual as you can, and you really don't need to you don't need to escalate a situation, particularly in a divorce where, as everyone's aware, the tempers and emotions are high anyway. So there's no need to fuel that fire.
Definitely.
All right, we'll move on to the next slide. We're a little bit over, but we only have a few more slides to go through. So if everybody wants to hang on, you can keep submitting questions, and we'll give a few more minutes, and we should be wrapping up shortly. Okay, what happens when the short sale lenders offer relocation assistance or closing incentives to divorced or separated sellers?
And this one I'm assuming is me. So absent an agreement, as a title company, we're going to disperse the funds to the parties that own the property. So if the property is still owned by both spouses, that relocation allowance is going to go to both spouses. I mean, we have had situations where we have dispersed it to one spouse versus the other based on who is actually in the property. But each short sale approval letter will address this or not. Sometimes it'll just say the sellers are getting a relocation incentive. Keep in mind that incentive is taxable income. So there are lots of issues. Who is it payable to? Who's going to pay the taxes on it? Sometimes the separation agreement deals with these things, sometimes it doesn't. Some lenders allow these incentives to be used towards the payment of outstanding liens on the properties, repairs, home warranties to be paid for, that are paid for so that we can incentivize the buyer to buy the property. There's so many issues around these relocation incentives, so it's one thing where when we get it and we're representing someone, we're representing the parties in a short sale, we want to make sure up front that they understand unless there is an agreement or it is addressed, we are issuing that check to both parties. And we've held it in escrow. We've held it in escrow for a year in some cases because they can't agree. And you would be surprised because some of these incentives can be $10,000, $25,000. And it can be a tough thing. So
Yvonne, that's what I was just going to ask. This is Kathleen again. I was just going to ask what a ballpark figure is for those incentives. And again, going back to our previous slide and previous question where we had a spouse who didn't want to cooperate, maybe this might be part of the conversation.
I use this as a carrot a lot of times to get people motivated, and depending on what type of loan they have. Certain loans have relocation or seller incentives built into them. FHA, for example, has some incentives built in. Now the HAFA program that's ending this year, it had some incentives. It was a $3,000, $10,000, depending on what type. So the loan type is very important. This is in particular something that a realtor should not be giving advice about. This is clearly legal advice. It is something that could be litigated later. Because the realtor maybe doesn't explain it properly, and at closing it gets dispersed to one spouse versus the other, and then it becomes, you cost me a $10,000 relocation allowance. And then the other issue that I want to point out that's just in relation to short sales in general, if a realtor is facilitating a short sale and fails to ask for a relocation assistance or a closing incentive, is that a problem? I think it is. I mean, every short sale that we negotiate, we ask for an incentive because my job is to represent the sellers and get them what I can get them. So if I don't ask, in my opinion, I've committed malpractice. So I wonder how many real estate agents that are handling short sales purposely ask for these incentives each time.
Right.
That's
another good point to ask again, or to emphasize again, that the realtors should be facilitating these transactions, not negotiating. What do the kids say now? Stay in your lane. The realtor has to stay in their lane, don't give legal advice. If it's a negotiation involved, that's when you contact your attorney or a title attorney or whoever's assisting you in working out the short sale, or assisting your client in working out the short sale.
Definitely.
All right, I think we're good for the last slide now. How does the title company divide proceeds of sale involving separated or divorced sellers?
Well, in my world, again, if we're doing a closing, the proceeds are always payable to the parties who own the property. So if husband and wife own the property, whether they're separated or divorced, our funds are dispersed to both, unless there's an agreement between them. And sometimes that agreement is very amicable, and we have what's called a disbursement authorization form, and they each sign off onto who is to get what, and there's no problem, and they agree. We review the separation agreements and judgments of divorce and orders that are in place, and we try to look at those agreements and work the numbers out for the parties. Oftentimes we're going back and forth with their attorneys. Sometimes we're instructed by both attorneys to submit the funds to one attorney or the other. Sometimes we're paying a trustee the funds. So it really is going to depend on what written agreements are out there and what we find when we do the title search. I want to point out to agents, though, a lot of times you're going to be getting these net sheets or these ALTA settlement statements that show a 0 at the bottom. And when we do cut a check to one or both of the parties, we're showing it on the settlement statement. So if we do divide the proceeds 50-50, we're going to have a line item that says 50% is paid to the husband and 50% is paid to the wife, and the bottom line is 0. And then it's very clear moving forward when the taxes are prepared, when we're looking forward in the future as to how everything went down, it's there. we're following RESPA rules and showing who the proceeds were actually paid to.
If I could pick up on that, Kathleen, if I could pick up on Yvonne's comments, this is an issue that really should be dealt with in the agreement. It isn't always, but so often the situation is that the one that stays and pays is supposed to get whatever proceeds are coming out of the property. That's not uncommon. And I want you all to know that it's also very typical that, properly done, there might have been a deed signed and placed in escrow years earlier with one of the attorneys for the parties. Because this isn't new. This isn't a short sale driven issue. This is a typical issue that should be dealt with in every agreement. Who gets the proceeds? It shouldn't be something that's subject to dispute at the settlement table. I mean, a lot
of things happen in 5 years, and that spouse that stays, that's paying the mortgage, oftentimes they look back at their agreement and they say, why am I splitting this 50-50? I've been paying down this mortgage for 5 years. Well, that's what you agreed to.
Yeah, get that agreement. You need to ask for and get that agreement and read it.
Definitely.
Well, you know what? We have one other question, and I think this might be our last one. It's a matter of crucial importance. Attorney's fees. The question was basically right. That's exactly. That should be the first question. No, attorney's fees. Can a divorce decree and the winning party, I guess, well, if to the extent there is a winner, can the attorney's fees be placed as a lien on the losing spouse's property? Or I was even thinking, would it be appropriate to pay the attorney's fees on the settlement statement?
Well, they're related, but they're really different questions. So as to the first question, can the attorney's fees become a lien? Yes. That lien can occur by contract, in other words, an agreement with the attorney, and subject to the same things we've already talked about this morning. It might not attach to the other party's interest in the property, but the instant the judgment of divorce occurs, the effect is the same. And that lien can occur by judgment. As part of the divorce judgment, that lien can occur.
So Chip, here's the situation. Who pays it? And this is what we get. The attorney's fees are $10,000. The proceeds are $100,000. The parties are splitting the proceeds. Does the 10 come out of one person's half? Does it come out first and then they're divided equally? This is the stuff that happens that could be avoided if we are talking about this up front.
Yeah, and the discussion up front has to lead to the writing up front. And listen, folks, I know you probably think that judges know everything and automatically put everything in their judgments of divorce. I want you to stop thinking that way. Judges are excellent, but they don't, quite frankly, most of the time, one of the attorneys is drafting the judgment of divorce, the other one is reviewing it. The judge will sign whatever both of them agree that it's supposed to say most of the time, and often none of this is dealt with in the judgment of divorce. If we're lucky, the judgment of divorce does actually incorporate but not merge that separation agreement, and if we're really, really lucky, this has actually been dealt with in the agreement. It should be.
It should be. And then you have the attorneys that actually will, I've seen. So this is a common situation. You have two parties that are divorced. Now they're tenants in common in the property, and one spouse owes their attorney a lot of money, and the attorney decides a really cool thing to do would be to take a mortgage on the property, and they can take a mortgage on the property, and I have the other spouse say, how is that possible? Well, because they're a 50% owner of the property, so the mortgage is there against their 50%.
Their 50% interest.
So it could throw a wrench into everything because that happens.
I think maybe Yvonne and I were just participating in a different seminar earlier this week, and an issue came up that's kind of related that I think might be helpful to each of you. Often, you're in the middle of a continuing battle between the divorcing or divorced spouses, and again, you got to be Switzerland. You got to be neutral. And many times, I'm understanding that somebody will throw out that, well, I'll just discharge those attorney's fees in bankruptcy. Bankruptcy often happens, in these situations, and that threat it's probably made more often than it's actually acted on. But the news here for each of you is, we learned the other day from a very good bankruptcy attorney that, in fact, if properly awarded, those attorney's fees are not dischargeable in bankruptcy. So if the judgment of divorce awards one of the spouse's a spouse attorney's fees payable by the other spouse, not payable to the attorney, payable to one spouse by the other spouse, that's not dischargeable in bankruptcy. It's a good piece of information for you to file away in the back of your minds, because I promise you, if you haven't already heard the argument, you will, and your ability to offer up something like, well, I've heard that, I seem to recall that, that's really not the case, that it's not dischargeable. That might be a reality check that changes the dynamics and gets people to do what they're supposed to do.
Yeah, definitely.
Right. I think I lied. I said that was the last question, and we actually have one other question. The question was, earlier this week, I settled a nasty divorce as the listing agent. Upon meeting with the sellers, I obtained the attorney's information so I could get clarification if I had any questions. As attorneys, are you okay with realtors contacting you?
I know that if a realtor contacted me and they asked me questions about information that I thought was privileged between myself and my client, I wouldn't answer that question immediately. I would tell them, I would understand why they're calling, figure out the contact with them, get their contact information. I'd say, look, I have to speak to my client, get authority to speak to you, and I will call you back. I mean, but I think you should understand that just because you have that contact information doesn't give that attorney the freedom, the ethical freedom to speak openly with you about everything. There may be things that he or she can speak with you about that aren't subject to attorney-client privilege.
Right.
I mean, it's just straight up privacy. We have to make sure that we're following our privacy policies.
Right. I think even just for, Yvonne, for purposes of preparing the settlement statement and dividing proceeds, for the parties, if they were requesting a copy of the separation agreement or the divorce decree, I think, again, they would still need authorization from their client before you could give that, before the divorce attorney could provide that typically.
Well, just to give that, a judgment of divorce is a public record. There's no privilege, there's no privacy, it attaches to that. And if one of the parties to the separation agreement wants to give it to someone, they don't really need the consent of the other party unless, and this would be weird, folks, unless the agreement has a term in it that says that it is to be held confidential. And in my over 30 years, I really haven't, I guess I've seen that tried. I wouldn't agree to it because ultimately it has to become public because ultimately we want them to become parts of judgments of divorce.
Unless it's a public figure that has addressed that, that's not really likely, but it could be there, definitely.
Right. All right, so I think we are good.
Well, thank you, everyone. It's been an awesome, very educating webinar. We are going to record this, and this will be posted on mdrealtor.org early next week. If you have any questions, please feel free to email HR, and we'll get back to you.
Thank you, Yvonne. Thanks, Fred.
Thank
you.
Thanks
Have a
for
good
the
day.
60 of you that held in here for 20 hours.